request that they give us their details.
Please. I appear with Mr. Anthony.
We have uploaded the charge sheet. I believe it is before you as well. We pray that the accused person's plea is taken, Your Worship.
49 years, Yamunyankole by tribe, a lawyer, and a resident of Chiwango, Namwezi village, Bukere parish, Goma sub-county in Mukono district. The statement of the offense is unlawful obtaining or disclosing of personal data, contrary to section 35, clause 1 and 2 of the Data Protection and Privacy Act, Part 97. Sarah Bireete and others still at large, between the month of January 2025 and December 2025 at various places within Uganda, including Kampala, Mukono, and Wakiso districts. You unlawfully obtained or disclosed data to which national voters' information controlled or processed by the Electoral Commission without prior consent of the said Electoral Commission. Have you understood the offense? Is this true?
Not true. We request for 5 minutes to access the charge sheet, since we have no idea what the charge is, and for us to be able to follow the charge and the plea taking process. It is a practice for investigating officers at the point of laying a charge to file an affidavit in opposition if there is anything that would militate against grant of bail. There is no such opposition. And the applicant has been in police custody. As Your Honor, therefore, would pray that that prayer is overruled and this point proceeds to determine the bail application. However, in the alternative, we are willing to concede to this matter being stood over after 3 p.m. for the state to make a response. Your Honor, thank God for technology, national IDs, passports, all these, the state has an electronic database. It's a matter of the state going on a computer and logging in, and they will know that, oh, this document is authentic, this one is not. Very simple. And therefore,
this being a case that has been brought to court by them, prosecution is granted time to prepare a reply to this application. Application shall be revisited on the 21st of January 2026. The accused person will be kept on remand till then.
Of my sister, we've been waiting for court. Finally, the illegality was now coming to a conclusion and they bring her to court. But I want to tell you for the first time now, in my heart, I'm regretting why I fought for women to be set free. To go and sit in a court and be a judge or a magistrate, and you judge like the way I have seen. I've never seen this. Now, here was the case. I don't even understand the charge. I don't even know. I've been telling you just, and I looked at this cigar. I stood there. I wanted her to see my face. She never opened her eyes up to see me. I don't know what I would have done if she looked at me. Maybe I would have been arrested in this court, because I would have said, very silly, you have no right to sit and judge, because you don't have the integrity to judge. Now I'm gone. Have anything to say? No wonder. The DPP, isn't that DPP? Yes. They are supposed to be the prosecutors. But the case they are bringing forward is that our Sarah revealed information of electoral commission or something without without the consent. So now question is, who is the complainant in this case? And now when we came to apply for the bail, We applied and gave everything, and we have distinguished, sureties, and everything was available. And the prosecutor stand up, he doesn't object. She didn't object to bail. And she's also a woman, banange. These young women. She didn't object to bail. And then what happens? The magistrate says, no, I'm not giving bail to you until 21st January. You know what that means? Sarah has been arrested to be shut down in a prison until elections. It was very clear, isn't that so? Nobody objected to granting of the bail. If I'm in a court seated there to judge justly and fairly, and somebody applies for bail, and the one who is accusing does not say, I object to the grant of this bail. Now me as a judge, how do I rule and reject the grant of bail?
Dr. Sarah Bireete has been charged with the offense of unlawful obtaining or disclosing of personal data contrary to Section 35 of the Data Protection and Privacy Act. The state has indicated that investigations are still ongoing. We therefore applied for bail and presented substantial sureties. And the state prosecutor indicated that she needed time to respond to our bail application, and to our great shock and surprise, the court has adjourned the matter to the 21st of January 2026 for the state to respond. In other words, the state has been given a whopping 20 days to respond to a bail application. I've never seen such a situation where the state needs 20 days to respond to a bail application, and it's very unfortunate. It contravenes the Constitution, even the bail guidelines, which were enacted by the Chief Justice, that bail application should be handled in a timely manner, and therefore we are disappointed that the court has granted a very lengthy and obviously unnecessary adjournment for the state to respond to a bail application. And therefore, as far as we are concerned, our client, Dr. Sarah Bireete, has been sentenced to 20 days of imprisonment. We cannot call this ordinary remand. This is a sentence that does not involve due process. Our client has been sentenced to 20 days imprisonment until the 21st of January.